welcome, Kevin. Please go ahead.
Thank you. So I'm going to open up my screen. Hopefully you guys can see my PowerPoint now. And so just to get started, again, my name's Kevin Urbatsch, and I'm an attorney. I'm based out of Berkeley, California, and I've been doing planning for loved ones with special needs for close to 30 years now. And, you know, this is an area that we have evolved over the years. You know, it really developed in the late 80s, early 90s, because primarily when we're talking about estate planning, we're talking about what happens to mom and dad, leaving assets to their loved one. You know, unfortunately, in the past, you know, disability oftentimes meant a shortened life expectancy. And because of advances in medical care and needs, what's basically happened is that people are living longer, you know, people with disabilities living longer and outliving their parents. And so this area has really, you know, blossomed. And part of what we're talking about today is kind of what's different about this, because primarily, you know, as an estate planning attorney, we oftentimes talk to mom and dads when they come in, and I'm just saying anybody, you know, even if they have a loved one with special needs or not, and we ask them what they've done for their own estate planning. And the most popular answer is doing nothing. So if you do nothing, your state probate code will have a list of where your stuff goes, how it's managed. And so that is, they do not take into consideration people with disabilities. And so doing nothing is not a solution if you have a loved one with special needs who might inherit money. And then as we talk on here, so let me get this. So really it's more than the money though, because oftentimes when I'm meeting families, you know, the money's important, obviously, but what's more important is how are we going to replace mom and dad and the support, advocacy, care, housing that they have been providing their loved one? Because, you know, typically they're the ones doing it for free. And if there's no one in the family who will help, or sometimes they think somebody in the family will help, and we find out later that that sibling oftentimes is not somebody who's going to do it. So this is why it's important to have a plan, think this through, and kind of stress test it with, you know, your loved ones and others. So that's why we plan. And then one of the traditional things that people talk about when they think about special needs planning is protection for public benefits, which is important. But I think, you know, any attorney who understands this area at all can create a plan that protects public benefits. The more important special needs plan is taking into account not only public benefits, but the lifetime needs of that loved one with special needs. So we're looking, you know, at financial security, public benefits, but we want to find the right people for lifetime management. We want to think about housing. We need an ongoing system for advocacy, caregiving. And then the other thing to remember is sometimes, you know, typically it's mom and dad in the office, or mom or dad. Sometimes it's grandparents, sometimes it's siblings leaving a plan. So sometimes there's multiple people who want to assist that person with special needs. So we need to coordinate all of their planning, because just one person not doing a plan but leaving money to somebody with special needs could screw up everything. So you have to make sure that there's a coordination with everybody. We also want to, you know, find protection against predators and undue influence from others. And then just, you know, as a backup, you know, where's the money going to go after that loved one with special needs uses it? So it's protection for heirs, or preserving assets for heirs. But to understand special needs planning, we really need to start focusing first on what public benefits are available. And this is kind of a big 5,000-foot view of what public benefits are. Now, the big one for most people with special needs is supplemental security income, or SSI. With SSI, in most states, you would automatically get Medicaid, which is the healthcare program that's, you know, set aside for persons with disabilities at any age. Oftentimes with the state Medicaid program, there's a housing program and even a caregiving program. So for example, in California, we have something called in-home supported services, or IHSS, and that is the state Medicaid agency in California will pay for a caregiver. They don't pay great, they don't pay 24/7, but one of the benefits of Plan A is trying to focus on getting as much money we can to be used for that loved one with special needs over a lifetime. Now, the issue with those benefits, SSI, Medicaid, IHSS, caregiving, whatever, those are what we call needs-based benefits. So not only does the person, do they have to be disabled, but they also have to be poor, and they can have no more than $2,000 in their name. And there's also an income component to this. So they have to be, they have to have very little income. That is the one where we're going to have to kind of plan around that $2,000 resource limit. Entitlement benefits are Social Security disability. And there's a program that, if you walk away from anything, remember childhood disabled beneficiary, CDB benefits. It used to be known as disabled adult child, or DAC benefits. This is an important benefit that I see missed a lot. And we'll talk a little bit about it later. And then part of Social Security disability and CDB is you also get Medicare. So it's possible to get both SSI, SSDI, Medicaid, and Medicare. But as we'll talk a little bit, trying to figure out which benefit the person's entitled to can be a little tricky. And oftentimes when I'm talking to family members, they don't even know which of these programs they're on, because SSI and SSDI are both run by the Social Security Administration. Check comes from the same place, and it can be very confusing. Healthcare could be paid for by Medicaid or Medicare if they have both, and sometimes it's hard to know who's doing what. The benefit of SSDI, that CDB and Medicare, they don't care how much money the person has in their bank account. So as long as you're entitled to that benefit, you get it. Elon Musk would qualify for Social Security disability if he was disabled, right? And there's a specific definition of disability. Now, whether or not he should take it is one other thing. That's a different discussion. But I'm just saying it doesn't matter if they have money in their names to qualify for SSD, CDB, or Medicare. Then there's some other benefit programs that are out there. Section 8, again, is for housing. Great program. Problem is that you can qualify for that program and never get it because there's huge waiting lists for it, or sometimes the government won't even open the waiting list, and you might wait years to qualify. But once you get it, it's a voucher that you get that you can use for rent, and you're only paying 30% of your own income for your rent, which can sometimes be like $100 for a $1,200 a month apartment. So it's an excellent program if you can get somebody qualified. Oftentimes our loved one with special needs may be a veteran or the child of a veteran. And so we want to make sure that we're identifying any VA benefits that might be available. And then every state has different programs. In California, we have something called regional centers. That's not in any other state. It's a great program for Californians because it's birth to death protection. And you have to make sure that you're not running afoul of any rules when you're kind of doing that. And then also the big thing about regional center, it may provide a lot of benefit, but it's not like you walk in, it's not like somebody's coming to you and saying, hey, I've got regional center benefits for you. Here's what you're available. Here's what your daughter, son could qualify for. You have to identify the benefit and then go after it, and they'll pay for it, but you have to advocate. So again, that's with a lot of these benefits. It's not something that, you just obtain because you qualify. You have to advocate and receive it. So if you are interested, there is a wonderful website called Disability Benefits 101. And you'll see it has different states here. And if you click, unfortunately, it doesn't have every state, but it does have these. And if you click on that, I have never seen a website so well maintained, so kept up to date, and so easy, relatively speaking, when you're talking public benefits, in obtaining correct information. It is, I've been using this for years, and sometimes even when, having done this for 30 years, I know a lot of this, but every once in a while I go, oh, what is that number? And I'll look this website up, and I'm amazed at how quickly they get stuff up. As soon as it's posted federally, federal law, it's on this website. So kudos to whoever's running this program. I don't even know who they are. I should probably reach out to them. But they do a great job. So remember how I was talking about SSI, Supplemental Security Income, and I said the person has to be disabled and they have to be poor. Disability, for people who may not be in this population much, sometimes people may see somebody in a wheelchair and say that person is disabled, but the government may not agree, because even though they might have a physical impairment that requires the use of a wheelchair for mobility, if that person is a coder at Apple and is earning $300,000 a year, they're not disabled under the federal definition of disability. So it's a physical or mental impairment that will last for more than a year, which is most of our developmentally disabled clients, obviously. But that disability must impair their ability to go out and get a job. They call it substantial gainful employment, and earn, I think, roughly around, I want to say, $1,100 a month. So that's the definition. Now, if you've ever watched late night TV or daytime TV, when they say if you've been injured on the job, you might be considered, disabled. That's the definition they're trying to meet. So it's important that to qualify for SSI or SSDI, you have to have that type of disability. If you pass that test, then we look at the resource and income test. And we'll talk about that. Resources are only tested at the beginning of the calendar month. So on day one, so what is it, September 30th, we look at October 1st, they do a snapshot test. Does this person, the countable assets that they have, are they under 2,000 or over 2,000? They're over 2,000, no SSI for the month. Then they go to the next month, okay? Same thing with Medicaid in most states. Then there's an income test, and this gets complicated, so I'm going to talk about it in a little bit. But what do you get? Let's say you qualify for all these programs. Federally, you get about $880 a month, and that's to pay food or shelter. Some states will supplement that amount. So in California, there's a supplement. So in California, we get $1040 a month, but most states just give the federal benefit rate. So the feds pay $880 a month, and then the state may supplement that. That's for an individual basically living on their own, paying all their food and shelter. Now there's some, if there's a married couple, it can be a little more, and there's other definitions, but this is what we traditionally see with most of our clients. And I've already talked about the definition for disability. This is the substantial gainful activity, and then you have that physical or mental impairment that will last for 12 months or longer. So as I mentioned, you only have a resource test of 2,000. If they're married, it's 3,000. You think it would be 4, but I guess I don't know why, but they've limited it to 2. That resource test has not been updated since the early 1970s. So it's not indexed for inflation. It's really kind of insane how low it is. It's just crazy, but that is the rules. And if you have $2,001 of countable assets on the first day of the month, you lose SSI for that month and possibly Medicaid. So it's a very strict test. Not everything is counted though. So you're allowed a primary residence. As long as it's a person's primary residence, they can have a home of any value. They can have one car of any value. All their furniture, clothing, personal care items, anything like that, computer equipment, all that stuff does not count against them. It's only really the, other stuff. And then there's weird stuff, like you can get a burial plot, some types of life insurance, but they can only have a cash value of no more than an immediate cash value of no more than $1,500. So if you buy an irrevocable burial, then that's fine because it has no cash value. So it's a little tricky when you get into it, but so those are the general basics. Now, here's where it gets a little tougher. When people think about income, a lot of times they're thinking IRS, Internal Revenue Code. Well, this is public benefits income, so it's a little different. The first one is more like the IRS, earned income or wages. But here's one that the IRS doesn't have, called unearned income. And that might be if, say, you left an inheritance to a person with a disability, you gave them $50,000, that is income. They count that as income for public benefit purposes. That would not be income for IRS purposes, but for public benefit purposes, it is. And we'll talk about the impact of receiving income. Then there's another one, I just hate this one too. It's called in-kind income, in-kind support and maintenance. Basically, if you have a loved one with special needs and they're living off $880 a month and they have to pay all their food or shelter from that $880, a lot of people, parents, want to, hey, I'll just give you $500 extra a month to help pay for your rent, or I'll pay your rent directly myself and you can live rent free. That's another kind of income for that loved one with special needs. And that's true if you pay their rent or their utilities. If you do that, there's going to be an impact on their SSI eligibility. The fourth kind is something they call deemed income. So this is if you have an adult who's disabled and they are married. If they're married, not only is their income counted and their resources counted, but their spouse's income and resources are counted as theirs as well. So sometimes when an adult is on SSI and they're thinking about getting married, this is a consideration. You know, if we get married, you may lose your public benefits because of their income and resources. Same thing if it's a parent to a minor child. So up until age 18, mom and dad's income and resources are counted as the child's. And that's why a lot of clients come into me and they're doing estate planning while their child's still young. And they're like, we don't get SSI. Why don't we get it? You don't get it because your income and resources are counted as theirs. On their 18th birthday, they'll qualify as long as everything is protected. Okay. So let's talk about, not all income is counted. We have a generous $20 of free income. So the Social Security Administration says, if you hand a person on SSI $20, we will not count that as income. But earned income, like let's say they go out, they get a job, for every $2 they earn, they lose $1 of the SSI check. So there's $880. So if they earn, $50, they would lose $25 off the SSI check. Now, there's also another exemption. I forgot the other generous exemption. If it's earned income, they also get $65. So you can earn $85 before they start deducting $1 for every $2 earned. Okay. Now this is the baseline for how they treat earned income, wages. Now, a whole nother program you could talk about is like working while on SSI. There are a bunch of programs that we won't get into where people can work and their benefits may not be impacted like this. There's Ticket to Work, there's the PASS program for achieving self-support. There's all kinds, because the government wants the people to, work, and many people are worried about working because they're going to lose their benefits. And so they've created these special programs. But again, you have to advocate for those. So earned income, every $2 earned, you lose $1 off your SSI check. That's pretty bad. This is worse. This is unearned income. So you remember when I said, if you, let's say you're a parent and you're giving your loved one with special needs on SSI $1,000 a month, that's treated as unearned income. After the first $20, it's a dollar for dollar reduction off the SSI check. So if you give them $1,000 a month, they've eliminated their SSI eligibility because it's only $880 they're receiving. You've given them a gift of $1,000. So if it's $880, you could give them, so basically giving cash to somebody on SSI is always a bad idea. There's different ways you can help them without impacting their benefits, and we'll talk about that. But giving cash, never a good idea. So unearned income, and so not only is it gifts, but it's inheritances. If somebody dies and leaves an insurance policy of $25,000, remember, they would treat that as unearned income. So let's say in September, somebody died and left your loved one with special needs a $25,000 life insurance policy. They would lose SSI for September because that's unearned income. And then on October 1st, if that $25,000 is still in their bank account, they would lose SSI because it's a resource and it's over $2,000 in the next calendar month. So it comes in as income, and then if you hold on to it till the next month, it's treated as a resource. It gets a little tricky, and I had to hear this about 5 times before I could figure it out. So don't worry, there won't be a test. But just understand that there is an impact on that. And then not only do we have this earned income, unearned income, now we have in-kind support and maintenance. And that's when a parent might want to give their loved one free room and board. And what happens is they will reduce the amount of the check based off if you're giving them, food or shelter. And basically the penalty, I won't go into they have a value of the 1/3 reduction rule, presume maximum value. Basically what they do is they take the federal benefit portion of the check, $880, and if they divide it by 1/3, they take that 1/3 penalty and they deduct it from the check. Okay. And so basically, the way I kind of describe it, initially, SSI was to pay for food, clothing, and shelter. And I think they felt that if somebody provided them food, clothing, or shelter, why should the government keep paying for it? And so, but instead of trying to calculate it out to the dollar, they just said, we're just going to make it a 1/3 of the federal benefit rate penalty. So a lot of times with our clients, we trigger this penalty on purpose because trying to live in California on SSI and not having any help is almost impossible. So we'd rather just have the parent or a special needs trust pay the monthly rent and utilities. They lose the 1/3. They're still getting 2/3 of the SSI check. They're still getting their Medicaid, but they're getting, a nice apartment, in a safe environment. They're getting all their utilities paid and all their food. So even if once you trigger the penalty by paying food or shelter, then the penalties hit and you can never. So if you pay for food and they trigger the 1/3, and then the next month you pay for food and rent, it doesn't go another 1/3. It's maxed out at 1/3. So once you trigger it, it's 1/3, and then you can pay for all of that stuff with no further penalty. Okay. So it's a good thing to understand, especially even if you haven't done your estate plan yet. If you have an adult child who's on SSI and you want to give them free room and board, just understand this is the impact. You'll lose 1/3 of the SSI check, and you have to decide whether it's worth it. There's ways to work around that with an ABLE account and other things that are, again, I'll talk about ABLE generally, but again, these get very specific. And then finally, I mentioned this already, a parent's income and assets are deemed to the minor child, a spouse's income and assets are deemed to the spouse. Okay, so that's SSI. Now I have programs where I do 2-day programs on Social Security Administration. So this is just kind of breezing over the very minimum that you really kind of need to understand about that in the future. Now, Social Security disability income, as I mentioned before, is different. And this is where people get confused all the time because I ask them, what benefit is your child on? Oh, they're on disability from the government. And most of the time they're really on SSI. SSDI, this is the disability insurance program that the federal government has put in place for you. And if you've ever gone out, worked, got your paycheck, you'll see little SDI deduction from your paycheck. Really what you're doing is you're buying a disability insurance policy. And that's what Social Security disability income, SSDI, is. So as long as you work for sufficient quarters and you meet that definition of disability, you'll qualify for SSDI, even if you have $10 million in the bank. All they're looking at is your disability. Now, the amount of benefit you get depends on how much you put into the system and whether you put in enough. The benefit of SSDI is we don't have unearned income. We don't have in-kind support and maintenance penalties. We don't care about deemed income. All that stuff is irrelevant for SSDI. So it's a much easier public benefit program to work with. And then if you're on SSDI for 2 years, you'll then qualify for Medicare. And generally, Medicare provides more doctors, better care, more choice than Medicaid. Now, there's certain parts of Medicaid that only Medicaid pays for and Medicare won't. So it's always a balance. And sometimes you can qualify for both. So what we're trying to do is make sure that the person is, if they're on SSDI, we need to know kind of how their healthcare is being paid for, because again, there might be a separate Medicaid test. I hope I'm not losing everybody. I think I'm getting a little into the weeds here. Hard to see when I'm just looking at my computer screen. I'm sure people are just cheering because this is so exciting. All right, so here is the program. If you're a parent and your child was disabled before age 22 and you've been working your whole life, or your spouse has been working their whole life, then your child with a disability on your retirement or your disability will get 50% of what your SDI, what you'll receive when you retire or become disabled. And it doesn't take away from the money you're getting, it's in addition. So it's 50%. So if you're getting 3,000, they'll get 1,500. And and that's great. And then if after you die, they're qualified up to 75% of what you receive. And if both parents worked, they take in one of the strange things where they actually give you a benefit, they pick the parent with the higher wages to calculate this. And again, it's an entitlement. It's not needs-based. So we don't care about unearned income, earned income, any of that stuff. They get it. Okay. Now, a couple things to remember. They have to have been disabled the entire time from 22. So they couldn't be like disabled before 22, then were able to go out and work for 10 years and make their own way, and then became disabled again later. You do that, you lose this benefit. So, and then again, you also get Medicare after 24 months. I've had clients come in where their loved one would have been qualified for this for 12 years because they retired 12 years ago and they never applied. So just make sure that you're doing that. And usually you get more money and there's less restrictions. It's really cool. All right, let's see. I see a couple of questions here. What if your child has 25,000 whole life? Will this? Yeah. So there's a question asking if the child has a 25,000 whole life insurance policy, will this count against them? Yes, it will. If it was a term policy, probably not, because it doesn't have a cash value. So if they were to try to sell that whole life insurance policy, they could get money for that. There's a cash value to that policy. Now, if that cash value is under $1,500, it's exempt. But if it's over that, it's countable. Okay. And what's the impact to benefits of an ABLE account? None. ABLE accounts are exempt. They're the most powerfully exempt assets that you'll have. And we'll talk about ABLE accounts in a minute. SSI upon retirement, does that count to the 2K? So this question on SSI, it's not really, so remember, we have an income test and a resource test. When you receive SSI per month, it's $880 a month. That doesn't count against you. But if you're receiving, remember how I said SSDI, you get 50%. Sometimes that 50% might be $300 a month, right? Based on what the parent paid into the system. If they get that, that's counted as unearned income for SSI purposes. So if you're on Social Security disability, and because mom or dad got you on childhood disabled beneficiary benefits, and you get 300, you would remember you get your $20 for free, and then they would reduce your check by $280, but you'd still have SSI, right? Because you have $880 max, and then you deduct the 200. I've already lost my math, 200 whatever off that. So you're still getting the SSI check, but so you're getting SSI, SSDI, you're on Medicaid already, and then you might qualify for Medicare after 2 years. Okay. All right, so let's jump here, keep moving. Gosh, already 10:35 in my time. Medicaid, like I said, is a really nice program. I know it gets a bad rap in some states because, you know, there's not a lot of doctors who accept it, hospitals, etc. But it does pay for two things at most you can't really find anywhere else, and that's long-term care. If they end up in a nursing home, that's a Medicaid paid program. You're not going to really find that anywhere else. Maybe a veteran benefit might have it for a veteran, but nowhere else are you going to find long-term skilled nursing care. Medicare won't pay for it unless you have a long-term care insurance policy. Private health insurance won't pay for it. So sometimes it's important to get Medicaid, even if they have private insurance or Medicare, because there might be things covered, and sometimes mental health. Sometimes the only access to mental health treatment is through Medicaid programs. Again, every state differs, so it's important to understand that. Now, Medicare is, you know, our government-sponsored healthcare plan. There's co-pays and the whole bit. Medicaid has no co-pays, so that's always a nice program. Medicaid is generally available if they're on SSI. Almost every state treats it that way. There's another type of Medicaid under the Affordable Care Act, where if the person might have too many assets to qualify for SSI, as long as their income is below 138% of the federal poverty limit, then they can qualify for free Medicaid, you know. And again, don't want to get too far down the path, but it's important to understand there's different ways to get Medicaid other than being qualified for SSI. And Medicare, you're again eligible for that after SSD and CDB. All right, here's the private healthcare access in most states, healthcare.gov. So sometimes if you're trying to get your loved one with special needs on healthcare, it's a good idea to go through this website to see if they qualify. And a lot of times, if they have very low income, they might direct you right to the state Medicaid program. California, we have a different website. Some states have different websites, but this is the general federal one. So let's talk about the next step, special needs trusts and how those are operated. So generally, as an attorney, we're trying to figure out, again, what mom and dad want. How are we going to keep mom and dad's advocacy, care management, all that great stuff that they need, you know, going forward. And it's important to remember that your loved one with special needs up until age 18, as a parent, you have the absolute right to make their decisions. You know, under law, nobody can question that. Although I guess I see on Facebook people doing it all the time, but I mean, legally question it. Now, when they turn 18, they are legally an adult and you've lost the right, the legal right to make those decisions. Does that mean that everybody on the planet is going to tell you to stop making decisions for your child with special needs? Absolutely not. Most people, I think, will continue to talk to you, you know, if you're doing IEPs or you're doing all the other kind of advocacy. You're in the room, you're helping make decisions. You might be doing supported decision making with that loved one, or you might just be making their decisions. But if somebody questions your authority, or your loved one with special needs says, I'm an adult now, I don't need you, you're out of the room. You're done. And they're making their own decisions. You have no authority to stay in. You have no authority to talk to the doctor. You have no authority to be in the IEP room if your loved one kicks you out. So one thing you can do is that loved one with special needs, if they have capacity, which is a whole nother discussion we could have, but basically it's if they understand enough that if they sign a piece of paper, they're giving mom and dad the right to make financial decisions for them, or they sign a piece of paper and they're giving mom and dad the right to make medical decisions for them, you at age 18, have them sign a power of attorney and a power of attorney for healthcare. We call it Advanced Healthcare Directive. Every state has a different one. Do it. Put parents first usually, and then put successors in, because the alternative to having that, if they don't have capacity to execute and you need to have legal authority, is a guardianship or conservatorship. And that's a court sponsored program that is not always, well, think Britney Spears, that's got a bad rap now. But in general, you might need that authority. You'll have these little pieces of paper that you take around and say, I have the authority to make decisions. You can't push me out of the room. So that's what a conservatorship or guardianship does for you. It gives you that legal authority. And when I'm advising my clients, I'm like, look, let's not sweat it. Let's not rush to court and get you these things unless you're absolutely certain you're going to have a problem. I've had some parents go, yeah, those IEP people hate me. And so they're going to do everything in their power to get me out of the room. So I want to have that legal authority. Some people go, I've never had an issue, making decisions. I'm always in the room. My child wants me there. I think you're probably okay until you make a decision, the doctor or the financial person doesn't agree with. And then all of a sudden, not having that legal authority is a big deal. And so even in that circumstance, there's usually an emergency temporary conservatorship or guardianship that an attorney can go in and get you. So again, it's not the end of the world if you don't have it right away. I guess there are scenarios where it could be you need it immediately. So some parents just go ahead and obtain it on the 18th birthday, and some just wait, and some never do. All right. So the durable power of attorney is nice because it gives legal authority for the agent nominated by your loved one to make decisions on their behalf. Downside, they can revoke it at any time. So they can say, you're my agent. And then they could say, you know what? I don't want you to have, you're no longer my agent. And now you're out. So that's one of the limitations. And they must have the capacity to contract, which, basically means they have a good understanding of what it is they're signing and what rights they're giving away. Advanced Healthcare Directive or power of attorney for healthcare, same thing. They have to have capacity to appoint that agent. And again, it's revocable. The reality of those documents is it's easier for financial institutions and doctors and hospitals to ignore them, even though they could be subject to a lawsuit. And sometimes we have to file a lawsuit because they just won't honor these documents. That's sometimes why we do a conservatorship or guardianship, because we have a court stamped piece of paper that they seem to respect more. So sometimes it's perception and not reality. But these are legal documents that are supposed to be honored. It's just, these are also documents I've seen ignored when they shouldn't be. The kind of the foundational tool that we use is the third party special needs trust. We call it that because the money that's going into this trust doesn't belong to the person with a disability. That would be a first party special needs trust, and that's subject to different rules. Third party trusts are like mom and dad setting up an estate plan, grandma, grandpa, sibling. Sometimes you'll see the GoFundMe accounts for a thing and you want the money to go into a third party trust, right? Because if it goes into the name of the person, that's a countable asset. That's unearned income for SSI, and it's going to disqualify them from benefits. The money held in a third party trust is exempt, doesn't count against that $2,000. The income earned inside the special needs trust does not get counted as income for public benefit purposes. So this is the place where you put the money, okay? And there's really, I think of it this way. With first party trust, like if, say, a lot of times I'm called in because somebody's become disabled because they were injured by medical malpractice or because they were involved in an automobile accident, and they're getting $1 million. And we know that the person A, can't manage the money, and B, basically if they get this money, they lose their benefits. So we set up something called a first party special needs trust, and the government is really interested in watching that money because they don't like to see people with money qualify for programs that are really designed for the poor. And so there's very strict rules with first party money. Third party, I think the government says, look, we want to encourage families to leave money to a loved one with special needs. So we relax the rules. They're much easier to meet the rules in a third-party trust, which also gives you a lot more flexibility for planning. Now, for a long time, when people were doing estate planning for loved ones, they would, again, if you get an outright inheritance, you're basically going to lose your SSI and your Medicaid. If it's left in a non-qualifying trust, a trust that doesn't meet those rules from the government, it's still going to be countable and they lose SSI and Medicaid. It used to be people say, well, you have to disinherit your loved one. You can't leave them money because of this issues with public benefits. But that's no longer the right way to plan. The right way to plan is to put the money into a special needs trust, right? Because then it's legally that beneficiary's money and no one can take it away from them. Because I still, from time to time, go, well, we'll just leave the assets to their brother or sisters or siblings and just ask them, hey, could you make sure to take care of your loved one with special needs? And I will tell you that even with the best, well-intentioned siblings, sometimes they marry someone who is not, who takes the money or spends it somewhere else. Or don't you think this money would be better spent on our kids rather than your sibling? Or I remember in 2008 when the housing crisis hit, all of a sudden everybody had to use money for their own housing, and all those kids with disabilities lost, the ability, to pay rent and stuff. So, and then also they, brother or sister, they could be subject to creditors themselves. And if they die, where does the money go? To a spouse or in-law that they don't even know. And sometimes, they just don't want to take care of their loved one with special needs. They just don't want to do it. And again, what happens if they get divorced? So this is why I think the special needs trust is really the right way to go. Now, I generally recommend setting up a special needs trust as a standalone document, but some attorneys put it into what they call testamentary trust, meaning it's inside your living trust or your will, and it only comes into existence after you die. The reason I don't like that is because what if grandma and grandpa want to leave money to a trust? If it's in a testamentary document, it doesn't exist yet. So you need a living special needs trust, meaning it's in existence. Usually I set it up so that mom and dad have it. It's amendable by mom and dad. If it receives money, it might become irrevocable, but usually just sits there with no money. And it's just there being available. The other thing to remember is that the beneficiary can never have a right to amend or revoke the trust, which is easy. It just should be drafted in the document. And the beneficiary cannot force distributions out for their own support or maintenance. And as long as you meet those two requirements, almost every trust could be a third-party trust. One of the issues you might run into with a traditional estate planning firm is there's a distribution standard from a trust called Health, Education, Maintenance, and Support. And it's a tax-driven distribution standard that they use all the time for the IRS. So you might see a trust saying, the trustee has the authority to distribute for the beneficiary's health, education, maintenance, and support. And that distribution standard used by almost every estate planning attorney in the United States will disqualify that person from public benefits because it includes maintenance and support. The two things Social Security says you can't, the beneficiary cannot force a distribution for, and you're saying that they have to make a distribution for. So you want to make sure that the person who's drafting your trust understands these rules, because many estate planning attorneys do not, and they'll defer to this tax thing that doesn't work. Here's the biggest issue you might have is who's going to be the trustee of that trust. The other reason I don't like to put the special needs trust in your living trust or will is because generally you might name your own sibling or maybe a child to be your successor. And that's fine, because usually with your will or trust, once you die, it might stay in existence for another 6 months to a year to wrap up the estate, and then it's gone. But a special needs trust could last for 50 years. And so you have to think through what happens if all these people I named die. I need to have a system for replacing them. And also with your living trust or other types of trust, you don't have to worry about things like public benefits, like that little blip I did at the beginning with the public benefit rules, that your head's probably spinning a little bit if you don't know the rules that well. Imagine some trustee trying to figure that out for the first time while managing the money. So here's the ideal trustee. They have to understand all the laws on how to manage a trust. They have to understand all the laws on public benefits. They always have to act in the best interest of the beneficiary, no self-dealing. They have to understand how to invest money for a person with a disability, which is its own expertise, because financial management is different, because when they do most financial plans, they're thinking this person's going to work. Most of our people can't work because of their disability. So it's like a retirement plan for an 18-year-old. So you have to invest it differently. They have to make tax efficient decisions, keep impeccable books and records. You have to carry insurance, because this is a very difficult job and the person has a lot of liability. If they make an honest mistake, they're liable and they have to repay the trust out of their own pocket. And so it's good for them to have insurance or deep pockets, okay? They have to be able to identify and rectify abuse or discrimination, or recognize second-rate service to that beneficiary with a disability. If you own real estate, they have to understand all the real estate rules. Care management is another big deal, because mom and dad may be doing it for free, but we may have to hire somebody later. If you're hiring a care manager and you're paying them cash and you're not treating them as an employee, you're breaking the law, because everybody, almost every law says if they're an in-home care manager, you have to treat them as an employee. And if IRS finds out, there could be huge penalties. And if that person gets injured, they're going to say, you should have, I can sue the trust now, or sue you for hiring me. And then again, you have to be a great communicator, be firm, but be able to say no. Understand the rules when you have to say no. And then my favorite is you have to be psychic, immortal, and omniscient. You do that, you've got yourself a great trustee. Now that's hard, right? That's a hard list. So generally, I try to break it up into different rules. Like the trustee, I always recommend a professional if you can find one. California, we have a great group called Private Professional Fiduciaries. It's licensed by the state. They have standards they must keep, and many of them specialize in being trustees of special needs trusts. Other states might have nonprofits, they might have CPAs, they might have all kinds of things. But again, I like the professional. But what's scary about the professional? They have complete discretion to decide how to use the money for your loved one with special needs. And what if they decide they don't want to spend the money? Who's going to keep them honest? And that's where you have a trust advisory committee. That's your family members and friends. And all they do is sit there and watch the trustee to make sure they're doing a good job. And if they don't like what they're doing, you let that advisory committee remove and replace the trustee at any time for any reason. Because that's the stick, right? You don't want that trustee just going off and not following your intent. And I usually add a trust protector. Now, none of this is mandatory. This is like my recommended team. So sometimes we say you don't have a deep bench. There's not a lot of people you can name. Sometimes the trust advisory committee is one person, So again, this is part of the consultation with an attorney. The trust protector's there because the trust is irrevocable. We may need to change it later. And so we have the trust protector appointed to just sign an amendment. And what that does is avoid having to go to court, and saves the trust like $5,000 to $10,000 of court fees and attorney's fees. So again, this is my kind of gold standard management team. But in planning for someone, you have to sit down and talk to them and figure out, where do you feel comfortable giving up control, adding control? So if you're looking for a special needs planning attorney or financial advisor in your area, there's a great group that I'm a member called the Academy of Special Needs Planners. Their website, specialneedsanswers.com. You log into it, and wherever you're located, you'll see special needs planners near you. So you'll see, hey, I am near me. So I'm on the bottom of the page there. And along with my associate, Jess Jones, and then Peter Wall is a financial advisor. You'll see there's 108 other planners in California. Now, not every state is covered, but almost all of them have multiple planners in your state. So this is a great place to find somebody who does this for a living. If I can tell you to do one thing I think creating a memo of intent is one of the best things you can do in addition to the special needs trust. Mom and dad, when they come in, all the knowledge of that loved one with special needs is in their heads. And even they have siblings growing up, they don't know half of what's going on, or even a fraction. Grandparents, aunts and uncles, they may know some things, but they don't know everything. And that's what a memo of intent will help guide those family members and friends. And it's really important to lay out your desires and hopes and wishes for those people. And so a memo of intent is kind of the best way to do that. Now, for many years, I would preach about how important it is to do a memo of intent. And so few of my clients would do it. So my wife and I, who's also an attorney out of Michigan who does special needs planning, we created a workshop for family members, complimentary, no charge. It's a 1-hour workshop at movingtomastery.com. And you'll see you can create an account, log in. In the workshop, we talk about the important things to consider in a memo of intent. We have fillable PDFs to kind of get you started. And so you can create your own memo. And once we did this workshop, I found that we started getting a lot more traction on getting people to do this. ABLE accounts. So this is, normally I would do a raise your hand if you've heard of these before, but I can't really see you. So I'll just assume you don't know anything about them. So if you know something, just, good. But an ABLE account is really cool. So if you're familiar with 529 plans for education, where you put money aside for your kids' college and university, ABLE account is designed similarly, but for people with disabilities. And you can put money in. It doesn't count against income. It doesn't count against resources. And the person with a disability can be in charge of their own ABLE account. They can never be in charge of a special needs trust. And so this is one way that they could get some self-determination and help manage their own life. And as long as the money's in there, it grows income tax free. And then you can make distributions out income tax free. And you keep eligibility. Now, a few rules. They have to have been disabled before age 26. Doesn't mean, you could be 55 qualifying for an ABLE account. You just have to be able to establish that you were disabled before age 26. Almost every state has their own ABLE plan. But if you go to their, each ABLE plan is, like California has a nice one, CalABLE. Michigan has a good one, MIABLE. Almost everybody has a plan. Ohio was the first, the stable account. And basically you just kind of look up the, check out your state plan. Sometimes you could join a plan from another state. They will allow out-of-state people. One of the rules is you can only contribute a total amount of $16,000 a year. And that's from all sources. So you can't put in $16,000 and your spouse put in $16,000 and the grandparent put in $16,000. In the aggregate, it can only be up to $16,000 a year. But remember, it grows income tax free. It comes out income tax free for what they call qualified disability expenses. But because ABLE accounts are run by the IRS, I feel that they're so much more generous to the disabled community than Social Security, because they basically counted almost everything as a qualified disability expense. Buying an iPad, using a phone, transportation, all of that they consider qualified disability expenses. I think the one thing we kind of figured out is maybe gambling debts may not be. I don't know. We haven't figured that out. We haven't seen them disqualify anybody, but if they do, then it would be taxed on a distribution for, say, gambling debts plus a 10% penalty. But again, I have not seen that happen. Now, as you keep your SSI until that account, the ABLE account, grows to over $100,000. If it goes over $100,000, you don't lose your SSI. It's just suspended until you pay it back down under the $100,000. So it's a good way for somebody to save. I know a lot of people with disabilities talk about using it to save, to buy a car or a modified van so they can have easier transportation. And if you don't like your ABLE account, you can move it to another. One of the downsides, though, is if there is, on your death or on the person's death who has the ABLE account, there is a payback to the state Medicaid agency. Some states have said they will not collect that. California is one of them. I think Illinois was talking about it. Oregon, a few other states have said they will not collect that payback, but most states will. So it's for whatever Medicaid that the person used while the ABLE account was enacted. So if you enacted it in September of 2022, all the way to their death, they would start with the Medicaid they used from that time going forward. And so I talked about conservatorship and guardianship at 18. So we talked about how important that is. And then basically, kind of when I talk about families doing, the considerations for what they need to do, it's often sometimes the first time they think about that person living with someone other than them. And where will they live? What supports do they need? What level of care is needed? Will a conservator or guardian be necessary? And who will do that? Is it the sibling? Because that's not always the case. A sibling may have their own life. They may move across the country. It's important to understand that. Who else is going to be involved with kind of lifestyle and that kind of stuff? I still think the third-party trust, you can use that in conjunction with an ABLE account. And if you say in your memo of intent, we'd like, our loved one to be able to receive money monthly from the special needs trust into the ABLE, then that person can control that money. Whereas if the special needs trust gave them cash directly, that would be unearned income and a dollar for dollar loss, right? But if you flow it through the ABLE account, no loss of benefits. You see, so it's kind of like legal money laundering. And so again, you want to be able to work with that to kind of help that loved one have the best life they can. And again, creating that memo of intent is critical. It's one of those things that on their birthday, you break it out, you update it for what happened in the last year. Use it as a trigger. And then you also need to kind of, then when we do create the special needs trust and we talk about all this great stuff, usually the next question is, how much money should I put into it? How much is needed? And so creating a budget for that is important. This is where the financial advisors can come in who specialize in this area. Remember, most financial advisors are thinking that person's going to work and I pay. We're worried about pensions and IRAs and 401k. No, I mean, you're looking at whatever you leave them, whatever the government gives them, and then whatever little maybe they'd be able to earn. And they may have big costs for housing, caregiving are the two biggies. They might need assistance with food, transportation. And so you have to sit down the finances. And so in the, there's like a little expense here. This is just kind of some of the general numbers. And then remember, I said this earlier, but I'll say it again. If your loved one turned 18 and they have capacity, have them sign that power of attorney for healthcare and financial management. Because, even if they're able to make their own decisions, it's a good idea to have that in your back pocket. And then again, you need to consider that conservatorship or guardianship if they do lack capacity. And then again, you make the decision on your own. The first party trust I mentioned, this is when that person gets money in their own. So sometimes it might be a legal settlement from a lawsuit. It might be, Uncle Bob forgot that the money was supposed to go to a third party trust. So they named the beneficiary, the descendants of you predeceased, it goes right to your kid with special needs. That is accountable asset. So we can transfer that to a first party special needs trust. But the downside of that trust is there's a payback to Medicaid on the death of the person with a disability from a first party trust. Third party trust, no payback. So that's one of the big things. If you plan in advance, you're getting a huge benefit for the family. So I usually end my presentation for the parents because I did a book called Administering the California Special Needs Trust. There's also one called Administering the Michigan Special Needs Trust. And it was funny because I did it initially because I kept getting the same 15 questions from families. What happens if we buy a coat? What happens if we do this? What happens? So I thought, I'll put a little 50, 75 page thing, question and answers. So my little 50, 75 page, now 620 pages, question and answers. And most of it is, usable in all 50 states because federal programs of SSI and SSDI, the rules are the same. State Medicaid might be a little different and state trust law might be a little different, but in general, that is, it's a good guide for understanding what issues come up. It's written in question and answer format. The other thing is, when I did seminars for family members, we go through this whole, the public benefits, conservatorship. And then a lot of times they go, well, what are your fees for doing this for us? And I would say my fees, and I see half the room would like, okay. And the other half would go, there's no way I can pay that. And so this NOLO Press book is a third-party special needs trust. And it has one in there that you can create on your own. And even if you don't use their trust and you've hired an attorney, it's not a bad resource to know what to ask the attorney to make sure they know what they're doing. Because if you start asking them about public benefits, if they don't understand what happens with SSI, then you know that you don't have an attorney who knows what they're doing.